In September 2021, Tropical Storm Ida ripped through the mid-Atlantic, and in Newark, New Jersey, at the United States Postal Service Processing Center in Newark, the roof collapsed during Tropical Storm Ida from the heavy rainfall. The U.S. Postal Service rushed to collect equipment, staff, mail, packages, and consolidate them at a different facility a few miles away in Teterboro, New Jersey. Within the first week of consolidating them, the Postal Service engaged in a constant process of trying to improve how to handle the doubled load. And during that period, at some points, boxes and equipment were put in places that had been preserved before for exit routes, and some wall-mounted fire extinguishers were blocked by boxes of mail or packages. And within that first week, somebody complained to OSHA. OSHA conducted an inspection and issued citations, one of them for exit routes and the other for fire extinguishers. We're going to talk about the fire extinguisher citation on this September 2024 episode of the OSHA 3030. Well, hello, everyone, and welcome to the OSHA 3030. I'm Manesh Rath. I'm an attorney here at Keller and Heckman, where I've practiced representing management in the field of occupational safety and health law for 25 of my 30 years, or almost 30 years, I'd say 28 years. And I'm joined today by my friend and colleague, Taylor Johnson.
Manesh, thanks for having me on the program.
Well, welcome. I think we got a great episode. I think one of the things that makes this such an interesting episode is not just that it talks about emergency plans as well as exit routes and fire extinguishers, but more importantly, when employers look at the inspection process and contesting citations together with their OSHA counsel, they should look at the standards and the scope of applicability of those standards and whether they even apply to the cited conduct, rather than just accepting that the standard should be evaluated in terms of compliance with the standard.
Yep.
And skipping that critical step. So that's why I think this issue is important and interesting today.
Absolutely. Yeah.
It's also nice to see, Taylor, we're talking about an issue for an episode where there were no serious injuries or fatalities. It's always so tough because you want to see zero people go home with injuries, or you want to see zero fatalities and see everyone go home safely. And so it's a relief to talk about a case which this was just a inspection that was based on an employee complaint. Nobody got hurt. Important to point that out at the outset.
Yeah, absolutely. Yeah.
Why don't we talk about what we're going to talk about today?
Yeah. So we'll go into the facts of this case, which is Secretary of Labor versus the United States Postal Service. As always with these cases, we'll unpack the four elements that OSHA needs to prove to establish a violation of an OSHA standard. And then we'll get into the arguments, Manesh. OSHA's argument, Postal Service's argument, and see who came out on top.
They both had compelling arguments, I thought, for why in OSHA's case they thought that there was an alleged violation of the standard, and I thought the United States Postal Service, the employer, had compelling arguments as to why, even if the requirements of that standard mismatched what the inspector saw during his walkthrough, that the standard shouldn't have applied to that circumstance in the first place.
Yeah.
So then we'll talk about the administrative law judge's decision and how he evaluated the comparative merits of both those arguments.
Yep. And then, as always, what employers should do. So we'll pull out some practical takeaways from this case for you to take back to your workplace.
Right. In some episodes we turn off, this is a live webinar and we repost it as a podcast. But in some episodes, we'll turn off the microphones during the live webinar, and for live webinar attendees only, have an after hours sort of off the mic kind of session. And we're not going to be able to do that this time because this is pre-recorded for the episode that'll be published in 2 Wednesdays.
Yep.
So we're going to skip that section and wrap up with what employers should do. Let me start before we get into this by saying, Taylor, as you know, this is a program we've done for over 12 years, and we do it complimentary to clients of the firm, Keller and Heckman, as well as friends of Keller and Heckman and the safety and health community generally. But we do it complimentary. The only recompense we seek is that you forward on the good word, because this is good education.
Yes.
So forward on the good word when you get an invitation, please. to at least three others within your organization and at other organizations, because you forwarding on your invitation to the OSHA 3030 to at least three others within your organization and outside, safety and health professionals and the Office of General Counsel at your organization or other organizations, that is going to secure the future of this program, hopefully for another 12 years to come and more.
Yep.
Well, with that said, let's talk about the facts. So, as I said at the outset, this all starts with a hurricane or a tropical storm Ida, that comes through the mid-Atlantic in September of 2021. And along with the long catalog of damage caused by Ida, the roof at the United States Postal Service processing facility in Newark, New Jersey, collapsed under the heavy rainfall.
Yep, that's right. And so what happened then was that the mail that was, going through the Newark facility was then rerouted to the Teterboro facility. So immediately that facility, overnight essentially doubled the number of packages that were being stored there.
And the number of staff, the staff all moved over.
Right. And so you could just
and
imagine.
the number of sorry,
Yeah.
and all the equipment, because Newark was specializing in large packages. Teterboro was mostly focused on flat mail.
Yep.
So all the equipment comes over as well. Now you've got a fixed amount of floor space with double the workforce, double the mail and packages coming through.
Yeah.
And now large packages, the size of the packages is increased,
Yep.
and the equipment, and you got to find a place to put it. And every day they're retraining every single person.
Yep.
Remember, U.S. Postal Service facilities like this are 24-hour operations, and every day they're retraining people based on lessons learned. They're adjusting to a unique emergency.
Right.
All week long.
Yep. Yeah, that was my point exactly. Is that you can bring over the people, right? And you can bring over the equipment. The one thing you can't do is expand the floor plan.
Yeah,
right.
That's right.
And so that's sort of the background that leads to eventually a citation. In this case, an employee complains and OSHA inspects the Teterboro facility and a citation is issued.
Yeah, and I think the reason this is important for me to point out is because even on the best day, the U.S. Postal Service, under the best circumstances,
Sure,
does what I think is a near miraculous job every single day. And they do it again day in and day out. The volume of packages and mail and the speed with which it's delivered and at the cost that it's delivered, door to door all over the country, is an enormous achievement in logistics, management side logistics. And now you have this calamity that causes this quarterback scramble at the last second, where they've got double the people coming in, double the equipment, double the packages, and every day they keep coming in and they need to be sorted and rerouted. And people who are coming in from Newark are not trained on the flat mail local distribution and outbound mail, as well as the incoming mail. They're mostly trained on packages. And conversely, the Teterboro employees were not trained on package distribution.
And the large ones, right? I think in particular. Yeah.
Right.
Yep.
And so this is an enormous achievement in management side logistics on a daily basis in the best of conditions. And now what they're doing in Teterboro, it needs to be emphasized, is another miracle on top of a miracle that is sort of their daily performance of miracles. And I think that it's an example of the kind of crises that management side needs to prepare for, consider, and have some kind of exercise where they go through what are they going to do if one of their many facilities at any organization, not just mail processing, maybe needs to double down on a failure in some other part of their system.
Right.
So that's definitely a backstory going on here. And within that same week, that every day they're recalibrating and retraining, one of the employees files a complaint.
Yep. One of the employees files a complaint. OSHA comes out, does an inspection, and actually issues a citation. They cited UPS for there being a gaylord of mail which obstructed a fire extinguisher, and this led to a citation under the portable fire extinguisher standard.
Gaylord is a term that can be used for any number of objects in shipping, receiving. We, as you know, Taylor, do a lot of work in distribution centers all over the country, in state plan states as well as in federal OSHA states. And the term gaylord is used interchangeably, but generally in this context would mean a dolly or a truck based large box that inside which other boxes, packages, or mail would be collected. So they're everywhere now at Teterboro.
Right, you can imagine.
Up against the walls and what used to be aisles, etc.
Yeah.
And so tell us again, what did OSHA find during their walkthrough?
Yeah, so OSHA found that one of these gaylords was obstructing employee access to a fire extinguisher, a portable, sort of wall-mounted portable fire extinguisher. And so that's where the citation stems from. Sort of, you can imagine the massive gaylord, in front of the fire extinguisher, employees seemingly to OSHA unable to access it.
Right. When Teterboro was originally designed and the fire extinguishers were mounted on the walls, the equipment was cleared of those wall-mounted fire extinguishers. The exit and access rows didn't interfere. Stacking of boxes or packages did not interfere. But now you've doubled everything up, and temporarily, one of the on-the-fly improvements during that week of transition that the management team at Teterboro implemented was to increase the number of sorting stations from something like 120 to about 190, one for each destination zone that the Postal Service was sorting their packages into.
Yep.
Which makes sense. If you have fewer sorting areas than zones that packages and mail are going out to, you've got to double down, do process twice using renewed, newly freed space, et cetera. And so it made sense to create one sorting zone for every destination zone. And so now, as you say, one of the things that the Occupational Safety and Health Administration compliance officer noted was that a gaylord was stationed or parked in front of a fire extinguisher.
Yep.
Clearly, only temporarily and for a very short period of time, and only induced by this recent urgent,
extraordinary circumstance.
Right,
yeah.
right.
Yep.
So the compliance officer issued citations. One of them was, by the way, for exit rows or emergency exits.
Yep.
But also the one we're talking about today was this gaylord, which was parked temporarily in front of a fire extinguisher.
Yep. And so again, we've gone over this, a few times on the program, but just to get everyone grounded here. So OSHA must prove when they're trying to, assert a citation that based on a preponderance of the evidence, sort of four factors here. The first, Manesh, that the standard actually applies in the first place.
The second would be if the standard applies, that there's an allegation that there was a failure on the part of the employer to comply with the specific requirements of that standard.
Right. The third, that employees were actually exposed to the violative condition.
Right. If there was indeed, as alleged, a failure to comply with specific requirements of the standard, but no employee was exposed to that hazard, then they would have failed to establish a violation of the standard in fact.
Yep.
And then the fourth is that the employer knew, or through the exercise of reasonable diligence, should have known of the allegedly violative condition.
Yep.
Again, even if the first three apply, but the employer didn't know and couldn't reasonably have known, let us say a circumstance appeared a second before the compliance officer noticed it, then even with the exercise of reasonable diligence, the employer couldn't reasonably have been expected to know about it.
Yep.
Then there wouldn't have been a grounds for issuing a citation that the employer was knowingly engaged in violative conduct or
That's right.
permitting a violative circumstance.
Yep.
So those are the four elements that OSHA has to establish in every instance where it alleges a violation of a standard.
Yes.
And that's key because a lot of our episodes, we talk about cases where OSHA has alleged violations of the general duty clause.
That's right.
Instead, right.
Yep.
And so
There's four elements there as well.
And they're different, right.
Yep.
And so members of our longstanding participants in the OSHA 3030 will have caught the difference. And you can go back and catch all of our prior episodes on our website, khlaw.com/OSHA 3030, where all of our prior episodes that cover cited standard cases as well as general duty clause cases
Yep.
Will be found in our library. Okay, so those are the four elements that they had to prove in this case because they were issuing a citation alleging a violation of a specific standard, the portable fire extinguisher standard,
Yep.
section 157. And OSHA argued, well, we think that the fire extinguisher standard requires employers to provide fire extinguishers and that they must mount them and locate them and identify them so that they are readily identifiable and readily accessible to the employee. And it is that last element that OSHA alleged that the Postal Service had violated when they had allowed a particular fire extinguisher on two different walkthroughs to be blocked by a box of mail, that they alleged that fire extinguisher was at that moment no longer readily accessible to the employees who might have needed them.
Yep.
That's OSHA's argument.
And then the United States Postal Service's argument. So they state, that essentially that OSHA is correct that covered employers do need to provide access to the fire extinguishers, but that the same section, or the same standard, different section, states that if fire extinguishers are provided but not intended for employee use, and that employer has an emergency action plan, an EAP, or a fire prevention plan, an FPP, then the standard actually doesn't apply. So you don't even need to go down to get to that step as to whether or not employees had access. The U.S. Postal Service is essentially arguing here that the standard doesn't even apply to them.
That's right. And at the Teterboro facility, the compliance officer examined the Postal Service's emergency action plan and fire prevention plan. And they found that these were compliant plans. These were well-crafted plans with respect to the standard. And so the quality or the compliance of the emergency action plan was not at stake anymore.
Right, right.
It's just that they believed that that if there are fire extinguishers, then OSHA alleged that they need to be readily accessible by employees. And when you look at the emergency action plan, it specifically states that employees are not to try and put out fires with fire extinguishers, that in the event of a fire, they must immediately execute on exiting the premises.
Yep, that's the key fact.
Orderly and quickly. Right.
Yep.
Right.
That's the key fact, and the Postal Service puts that up as evidence of these fire extinguishers were not intended for employee use. Look at our emergency action plan; it doesn't tell them to do anything with them. It tells them to just get out of the building.
So that's the emergency action plan. Now they interviewed scores of employees, and they all as to how they were trained, and every one of them said we were trained that in the event of a fire, even a fire that could be combated with a fire extinguisher easily, to commence immediately to exiting the premises. The Postal Service presents all of this testimonial evidence to say not only was that the policy, but employees were trained in accordance with the policy not to use fire extinguishers, but to just leave.
Yep.
OSHA, of course, points to two employees who had special duties.
Yeah, OSHA comes back and says, wait a minute, there's two employees here that were trained to use fire extinguishers during welding and grinding activities. Right. And so you can't say that you didn't train your employees on how to use fire extinguishers because these two employees were trained on how to use fire extinguishers. So
these two employees, if one of them was welding or grinding, and the other would stand by with a fire extinguisher at their side on the ready in the case that sparks maybe led to a fire that could be easily put out within a second of its starting. And so OSHA pointed out that, well, no, not all employees were trained to leave and not use the fire extinguisher. There were two employees who used fire extinguishers, or at least had them ready, and believed that their training with a specific respect to welding or grinding were trained to use the fire extinguishers.
Yep.
And that is true, but it wasn't with respect to the emergency action plan or an emergency fire.
The context matters here.
Right.
Yeah.
So those are the arguments going back and forth, and I think they're very compelling on both sides.
Yeah, I agree. And so, the ALJ hears the arguments and in the end decides that, OSHA's theory that the fire extinguishers were intended for employee use, sort of pointing to that welding, training, was unpersuasive, essentially. And eventually, the citation here is vacated.
But why would an employer have wall-mounted fire extinguishers if it's not intended for employee use? Of course, it's required as an element of a fire code in any municipality I can think of, but it's also available for use by trained emergency responders.
Sure.
So that they can access fire extinguishers if their own equipment may not be able to reach a certain spot. And so that there may be a lot of reasons why there would be well-mounted fire extinguishers, even though employees, for the purpose of achieving greater employee safety, are directed not to use them, but to simply exit the premises or evacuate. So it makes sense. And I don't support OSHA's view that the fire extinguishers were there and thus they were clearly intended for employee use. And of course, as you already said, if the evidence flies in the face of that assertion, the EAP says that employees are not intended to use these. They need to exit and protect their own safety, mind their own safety, and their own training that every one of them testified was consonant with that.
Yeah.
Okay. So those seemed to be dispositive pieces of evidence for the administrative law judge.
Yeah, I think especially the EAP. I mean, the level of detail in there, I think, really ends up, kind of pointing towards the, the standard not applying in this instance, that they really took that step to actually say, do not use these, you know,
Right.
just immediately evacuate. I thought was key.
Right. And so unless the judge said, unless OSHA can show that the employer placed fire extinguishers for the purpose of employee use, the standard itself doesn't even apply. It only applies
Yeah.
in instances where fire extinguishers are provided for employee use. And that is one of the rare instances in the entire catalog of OSHA standards where a standard only applies when an employer takes an elective action.
That's a great point.
Emergency responders is another example. If you have emergency responders, then the emergency response standard applies.
Yeah.
But this is another example of one of the very, very few OSHA standards where an employer takes an elective action and thereby subjects the facility or establishment to a specific OSHA standard or set of standards. And here the administrative law judge said that the employer had not elected to subject itself to the fire extinguisher standard,
Yep.
specifically because those were not fire extinguishers supplied for employee use. So in light of that, and then vacated thereby that standard. The other standard that I've alluded to, the emergency exit allegedly being blocked, the administrative law judge found in favor of the agency, by the way.
Right.
And found it to be a repeat. So it was a fairly heavy penalty, $94,000 in that neighborhood. But for the purposes of today's discussion, the fire extinguisher standard, let's talk about what employers should do in light of this case.
Yeah. So I think the big takeaway here is, review your emergency action plan. Do you have the level of specificity, right, that the Postal Service had in this case with respect to who should and who shouldn't use fire extinguishers? If your plan calls for employees to use fire extinguishers, if needed, then they certainly do need to be accessible. I think that's one clear, takeaway from this case.
That's right. And I think that in addition, it's important for employers to start, in light of this case, with going back and reviewing your emergency action plan, your fire extinguisher compliance
Yep.
protocol, looking at the tags and making sure that they've been inspected with the requisite annual frequency,
Yeah.
and doing a walkthrough and looking at the aisles, exits, exit markings, and making sure that, when you look at distribution centers like what you see in Teterboro, but all across a number of industries, you will see that these are living, changing sort of organisms. The facility itself, the establishment itself, is a living, changing organism where boxes are being set, then they're being stocked, and then they're being pulled down, and orders are being fulfilled. And because of this, it's important to constantly engage in ongoing monitoring to make sure that all of these ongoing changes don't encroach on the pathways that are intended for emergency use.
Yep.
And that there are clear aisles, marked exit pathways, et cetera.
Yeah. Another takeaway, I think, is, discipline instances of non-compliance. For example, if in the USPS scenario here, if an employee, let's say they had a fire drill, an employee just grabs a fire extinguisher, right? Let's document that. Let's go through. Let's have in the record, have it show that that's not our practice.
I think that's right. And another example would be in your daily gambles or walkthroughs, if you find maybe a pallet has been placed in an exit pathway.
Yep.
That you not only correct that promptly, but also try and understand how it happened and whether or not a reprimand or coaching and counseling are warranted in that instance.
Yep.
Because that would constitute an ongoing effort to not only monitor for non-compliance with your internal policies, but also disciplining or reprimanding or coaching and counseling when you do discover non-compliance.
Yep.
And then finally, I'd say memorializing those disciplinary records
Yes.
or reprimands or coaching instances.
Yes.
And the findings in your walkthroughs.
Absolutely agree.
I think that's critical for everyone listening to today's OSHA 3030. Ultimately, I think that this all starts with regular training for employees and on the emergency action plan and all of the elements of exit routes, exit procedures, et cetera.
Yep.
And if you can conduct that regularly, keep records of attendance, the content that was covered, that'll help you as well when you conduct interviews for employees during an inspection, or should avail you that you had that record, that those folk were trained and trained properly.
Yep. Agreed.
That's what employers should do. That's the last thing we want to cover in today's OSHA 3030. We want to talk about the next OSHA 3030, really critical. We have a date uncertain. We're going to be looking potentially at Wednesday, October 9th, at 1 p.m., always on a Wednesday, always at 1 p.m. Eastern, US Eastern time. We'll announce a topic shortly. We're hoping to have a special guest come on board, the OSHA 3030. And please, when you get your next emails inviting you to the next OSHA 3030, note the date and calendar it accordingly. And please forward it on to at least 3 other people, your Office of In-House Counsel, Safety and Health Professionals at your organization, and in-house counsel and safety and health professionals at other organizations where you know folk interested in the safety and health community and making workplaces safer. This will be a really important episode coming up. We think October 9th.
Yeah.
So please watch your email inbox and make sure you remember to forward it on to at least 3 others when you get it, and calendar to set time aside to catch this next episode. We think it'll be a great one. And again, we're talking about potentially October 9th.
Okay.
So that's next month's OSHA 3030. I want to talk about our sister programs, the REACH 3030 and the TSCA 3030. If your organization is engaged in operations that are subject to compliance with REACH or TSCA, please calendar October 16th and for both programs, and forward the good word about those programs on to your colleagues who are responsible for compliance with REACH or with TSCA. Well, on behalf of everyone here at Keller and Heckman, all of our staff who did a great job helping put this program together, and on my own behalf, as well as Taylor Johnson, thank you all for participating in this month's OSHA 3030. We're grateful to you for your continued support of the program. Thank you. And we look forward to seeing you again next month. And until then, stay safe.